Hello, I'm Judge Dan Slayton for the Coconino County Court System. You know, landlord-tenant law can be confusing to both the landlord and the tenant. It is controlled by numerous statutes that sometimes are hard to understand. This video is prepared in the hope that you will better understand the principles which govern the landlord-tenant relationship. Now, this video should not be taken by the viewer as giving or replacing sound legal advice. It is not our intention to cover all of the statutes that may govern a specific issue or answer a specific question in the next few minutes. What we hope to present to you is a starting point for landlords and tenants to learn some basic legal concepts that will enable them to have a better understanding of the duties and law regarding landlords and tenants. Understand that the relationship between a landlord and a tenant is governed by the Arizona Residential Tenant Act. These statutes are very explicit in the obligations expected of both the landlord and the tenant. At the end of this video, we have provided a website address where you may view and download the Arizona Residential Tenant Act. I strongly urge both landlords and tenants to read this act before you enter a lease agreement. Also, if you are renting a mobile home space only, the Arizona Residential Tenant Act does not apply. The statutes that govern the renting of a mobile home space only are governed by the Arizona Mobile Home Parks Residential Tenant Act. We will provide you with a website that you can review and download the statutes under that act. Now, as we go through some of the statutes, I may only refer to the Landlord-Tenant Act. Please understand that I am referring to the Arizona Residential Tenant Act, not the Arizona Mobile Home Parks Residential Tenant Act. Also, during the course of this video, you will hear me talk about the obligation of either the landlord or tenant to give notice to the other party. Notice, as it is used in this video, means that a person gives notice by taking steps reasonably calculated to inform the other person by ordinary means whether or not the person is actually aware of it. Notice must be given either by hand delivering the notice or by certified registered mail to the place specified by the other party for accepting that notice, such as the landlord's place of business, the tenant's rental unit, or last known address. Finally, you will hear me use the word days in calculating the time that an act or notice must be given. Days, as it is used in this video, refers to business days, which means in counting those days, you do not include weekends or holidays. However, some statutes may specify that in fact you count calendar days. In that case, you would include both holidays and weekends in counting the number of days necessary. With that said, let's begin with some basic principles of the landlord-tenant relationship. The first principle is that both parties are expected to negotiate the agreement in good faith. Now, underlying the relationship between the landlord and tenant is a duty of good faith, which simply means that both the landlord and tenant have a right to receive the benefits of their agreement without interference from either party. Remember, the lease is a type of contract which obligates both parties to do certain things, like paying rent by a certain date or maintaining a safe and secure place to live. If you as a tenant are unclear of the meaning or intent of any word or paragraph in the lease, by all means ask for an explanation before you sign the lease. Now let's first look at certain landlord obligations. A tenant can be required to post a security deposit as long as it does not exceed 1.5 months' rent. A security deposit does not have to necessarily be money. It could be some type of property as well, but the choice is left to the landlord. The purpose behind a security deposit is simply to assure payment or performance under the rental agreement. Also, a security deposit does not include a reasonable fee charged for redecorating or cleaning. Finally, keep in mind that any amount of deposit that is not clearly stated as non-refundable will be considered as a refundable deposit to the tenant upon termination of the tenant's lease. After the lease is signed, there are 3 documents the landlord must give to the tenant. First, they must give a copy of the signed lease agreement. Second, they must give a move-in damage form the tenant can use to specify any pre-existing damage to the property. And third, they must give written notice that the tenant may be present at the move-out inspection after the lease ends. Now, it is strongly recommended that the tenant be as clear and as precise as possible about any damages they note at the time they move in. Questions that arise at the end of a lease about damages that happened before the tenant moved in or during the tenant's lease can easily be answered and disputes avoided by a move-in form that is clear and precise about any damages that existed at the time the tenant moved in. A second potential area of disagreement is the amount of damages the landlord believes was caused by the tenant during the tenancy. In order to lessen the potential for disagreement about any damages caused by the tenant, it is also recommended that the tenant join the landlord during the move-out inspection. While there may still be areas of disagreement, at least the parties have had a chance to talk over the damages observed and to try to come to some agreement about a reasonable cost for repair. Finally, the landlord and tenant have certain obligations about returning the security deposit. At the end of the tenancy, the tenant must make a demand for the return of any refundable portion of the security deposit. It is recommended that the tenant make this demand in writing, but it is not required by law. Within 14 days, excluding weekends and holidays, the landlord must provide to the tenant an itemized list of all deductions made, together with any refundable amount due the tenant. If the landlord fails to follow this requirement, they may be liable for any refund due the tenant, plus double damages. The third principle is the landlord's duty to maintain a fit and habitable rental unit. What exactly does this mean? Well, the statutes are very explicit about the landlord's obligation to maintain a fit premises. Among the many duties a landlord must follow are to comply with applicable requirements of building codes materially affecting health and safety, to make all repairs necessary to put and keep the premises in a fit and habitable condition, to keep all common areas of the premises clean and safe, to maintain in a good and safe working order and condition all utilities supplied or required to be supplied by them, to maintain in a good and safe working order all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities and appliances, including elevators, supplied or required to be supplied by them, and to supply running water in reasonable amounts of hot water, heat, and air conditioning when required by the season and where offered by the landlord. This list is not exhaustive, and both parties would do well to read the Landlord Tenant Act for a complete list of the landlord's duty to maintain a fit premise. Remember, too, that a landlord and tenant can agree that utilities such as heating and hot water will be placed in the tenant's name and paid for by the tenant. Now let's look at some of the obligations the tenant has to maintain their dwelling. Under the Landlord Tenant Act, the tenant must keep the part of the premises that they occupy and use as clean and as safe as the conditions of the premises permit. Second, they must dispose of all ashes, garbage, and other rubbish and waste in a clean and safe manner. Third, they must keep all plumbing fixtures in the rental unit or used by the tenant as clean as their condition permits. Fourth, they must use in a reasonable manner all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities and appliances, including elevators in the premises. Fifth, they must not deliberately or negligently destroy, deface, or damage, or impair or remove any part of the premises or knowingly permit any person to do so. Sixth, they must conduct themselves and require other persons on the premises with their consent to conduct themselves in a manner that will not disturb their neighbors' peaceful enjoyment of the premises. Please understand that a tenant will be responsible for all damages beyond those considered normal wear and tear. Now, during the course of a tenancy, a landlord has the right to either change or make new rules or regulations. The landlord must comply with the statutes, though, when changing or proposing new rules. For example, the purpose of the new rule or regulation must be to 1. Promote the convenience, safety, or welfare of the tenants in the premises. 2. To preserve the landlord's property from abusive use. And 3. To make a fair distribution of services and facilities made available to the tenants. Further, they must apply to all tenants on the premises in a fair manner. A rule or regulation that is changed after the tenant enters a lease is only enforceable against a tenant if the tenant is given a 30-day notice before it takes effect, and it will not make a substantial modification to the tenant's rental agreement. Another principle that underlies the relationship between a landlord and tenant is the landlord's right to access the rental property. This statute governs when and under what circumstances a landlord can access their rental property. First, a tenant cannot unreasonably withhold consent for the landlord to enter the rental unit. However, the landlord must be entering the unit with a valid reason, such as to inspect it, to make necessary agreed-upon repairs or improvements, or to show the unit to a prospective tenant. A landlord can enter without consent in an emergency. And, except in an emergency, a landlord must give at least 2 days' notice of their intent to enter the dwelling unit. If you are a landlord, remember that it is always a good practice to give written notice to the tenant and to explain why you wish to enter the unit. Further, you cannot enter a rental unit at an unreasonable time. Another area of confusion is whether or not a landlord must accept a partial payment of rent from the tenant. The law is very clear on this question. A landlord is not required to accept a partial payment of rent or other charges. Now, if a landlord accepts a partial payment, they retain the right to proceed with a forcible detainer against the tenant only if, 1, the tenant agrees in writing, made at the time the partial payment is accepted, to the terms and conditions of how and when the balance shall be paid with regard to the continuation of the tenancy. In other words, the landlord has the obligation of making a written agreement between themselves and the tenant that clearly explains when the balance is due, and that the landlord is not waiving any right to evict the tenant should the tenant not pay the balance by the agreed due date. A failure of the landlord to get this written partial payment agreement will prohibit the landlord from terminating the tenancy for that breach. Sometimes even the best of relationships between a landlord and tenant can become disagreeable. If that happens and one party breaches the lease, what remedies does the other party have for that breach? Let's first look at what remedies a tenant may have for certain breaches committed by the landlord. Certain remedies are available only for certain kinds of violations of noncompliance by the landlord. The tenant must decide under which statute they wish to assert in order to gain the benefit of a particular remedy. Under ARS 33-1361, if a tenant believes there has been a material noncompliance regarding a material falsification of the written information given to the tenant can take one of the following steps. They must provide written notice to the landlord that specifies the acts and omissions constituting the breach, and then tell the landlord of their intent to terminate the lease within 10 days of receipt of the notice if the breach is not remedied within those 10 days. If the tenant believes that the landlord has committed a breach of the lease, materially affecting the health and safety of the rental unit or premise, the tenant must take the following steps. They must provide written notice to the landlord that specifies the acts and omissions constituting the breach, and then tell the landlord of their intent to terminate the lease within 5 days of receipt of that notice if the breach is not remedied within those 5 days. The tenant should remember that if the landlord repairs or remedies the breach within the time period given, the tenant cannot terminate the lease. Since we're talking about a landlord making repairs, let's look at under what circumstances a tenant may be able to make their own repairs and deduct the cost from their rent. This is called self-help for minor repairs. As we have seen, a landlord has an obligation to maintain a fit and habitable rental unit. However, a tenant may be able to have minor repairs done and deduct the cost of those repairs from their rent. There are certain steps, though, that must be followed by the tenant. Failure to follow the steps could mean the tenant winds up paying for the repairs and the full month's rent, too. First, the cost of repairs cannot be more than $300 or more than 1/2 month's rent, whichever is greater. Remember, these are minor repairs. Second, the tenant must give written notice of the condition that needs to be repaired and their intention to contact a contractor to make the minor repairs. Third, the landlord must be given 10 days to correct the repair, or in case of an emergency, as promptly as possible. Fourth, the tenant must use a licensed contractor to make those repairs. Fifth, the tenant must give the landlord an itemized bill of the repairs and a lien waiver signed by the contractor. Only after the tenant takes these steps may they then deduct the cost of repairs from their next month's rent. Also, the tenant cannot use this statute if the damages were caused by the tenant, a member of their family, or a guest. Another area of the Landlord-Tenant Act that a tenant may assert is the landlord's failure to supply necessary utilities or essential services. If a landlord either deliberately or negligently fails to supply those utilities which are essential for a tenant's physical needs and comfort, such as hot water, heat, or electricity, for example, the tenant may take one of several actions. First, the tenant must give reasonable notice to the landlord of the breach or violation of providing essential services. If the breach is not repaired within a reasonable time, the tenant has three options available to them. They may purchase reasonable amounts of the essential service that is unavailable during the period that they are unavailable and subtract the reasonable cost of that service from their monthly rent. Or second, they may recover money damages based upon the decrease in the fair rental value of their rental unit. Third, they may purchase reasonable substitute housing during the period of the breach or repair. Now, there are limitations on how much a landlord has to pay for tenants exercising their right to this last option, so a tenant needs to read the statute very carefully. Also remember that the substitute housing must be reasonable in its cost and can only be up to 125% of your monthly rent. What if the tenant is not in compliance with the rental agreement? What remedies does the landlord have? If there has been a material noncompliance with the rental agreement by the tenant, the landlord may deliver a written notice to the tenant specifying the acts or omissions that constitute the violation or breach, advising the defendant they have 10 days to cure the breach, or the lease will terminate after 10 days. If the tenant has made a material falsification of their information, such as failing to disclose a criminal conviction or the number of people or pets occupying the rental unit, the landlord has the right to terminate the lease simply by providing notice that the lease will terminate in 10 days. The law does not allow the tenant to try and set things right by attempting to correct the falsification. If there is a material noncompliance by the tenant materially affecting the health and safety of the premise, the landlord may deliver a written notice to the tenant specifying the acts or omissions that constitute the violation or breach, advising the defendant they have 5 days to cure the breach, or the lease will terminate 5 days later. Tenants should understand that even though they may have remedied the first violation, if there is a similar or same type of violation during the lease, the landlord need only give a 10-day notice stating that there has been a second violation. The landlord may then begin eviction proceedings against the tenant. Finally, if the tenant commits a breach that is both material and irreparable, such as fighting or allowing the use of illegal drugs on the premises, or any act that poses a serious and imminent threat to the safety of any resident, landlord, employee, or the property, the landlord may give written notice for immediate possession of the premises and begin eviction proceedings. In addition, the tenant should understand that the landlord can begin these proceedings even though their rent may have just been paid in full. Perhaps the most frequent act committed by a tenant that results in eviction proceedings against them is the non-payment of rent. If a tenant fails to pay rent on the date it is due, the landlord must give written notice that the rent must be paid in full together with any late charges within 5 days of receipt of that notice, and state their intention to terminate the lease if the rent is not paid in full. So far, we've seen certain obligations that the landlord and tenant must fulfill, and some remedies that both parties may assert if the other party is believed to have breached the lease. Now let's look at what exactly a forcible detainer action involves. There are two types of detainer actions that can be filed, either a forcible or special detainer. A special detainer can be filed for any alleged breach of the lease, from failing to maintain the rental unit to non-payment of the rent. A forcible detainer is brought under the allegation that the tenant is in wrongful possession of the premises by virtue of violating the lease. Keep in mind that whether an action is brought as a forcible or special detainer, the purpose of each is the same. It is to provide a summary and speedy remedy for determining the right to possession of the property and any damages that may have resulted from the wrongful possession. Courts can only decide two issues. One, which party has the right to possession of the premises in question, and two, any damages that flow as a natural result of the wrongful possession. Normally, a forcible detainer action is started by the landlord for an alleged breach or violation of the lease. However, it is possible for a tenant to bring a forcible retainer action against the landlord if the tenant believes that the landlord has made a forcible entry by asserting possession of the property against the tenant. The landlord will file the complaint with the allegations of the breach and stating why they are entitled to possession and damages. This complaint, with a summons, must be served upon the tenant. A tenant must be served notice of the forcible retainer hearing at least 2 days prior to the hearing, according to applicable statutes. If the total amount of damages sought is $10,000 or less, excluding court costs, interest, and attorney's fees, that action will be heard in justice court. If it is more than $10,000, it will be heard in superior court. Now, a forcible retainer hearing can be postponed only upon good cause and by sworn affidavit. It can only be postponed for a maximum of 3 days in justice court, 5 days for superior court. At the hearing, the landlord will have to present evidence that supports their claim to possession, the evidence constituting the breach, and the damages that they believe they have suffered. The tenant can present a counterclaim only if it is reasonably related to the terms of the lease, and second, if the landlord has been given notice of the counterclaim prior to the hearing. A tenant is not permitted to simply assert claims and defenses at the time of the hearing without evidence and absent the claims being reasonably related to the lease. This means, for example, that if a tenant had an agreement to fix the landlord's car in return for a reduction in the rent, that agreement must be part of the lease, or it cannot be raised in a forcible retainer hearing. Finally, as with almost all civil hearings, either party retains the right to appeal the judgment of the court, but there are very specific rules for how the appeal must be pursued, and landlords and tenants are urged to read those statutes as well. Again, you are cautioned not to rely on this video for specific legal advice, as I have not gone over each statute under the Landlord Tenant Act that may affect your particular situation. If you have questions of a legal nature, I urge you to seek the assistance of an attorney who can discuss your specific concerns and questions and the law that may address those questions. I also hope that this significant area of the law is a little more understandable and that you will familiarize yourself with the statutes. The website that you can view the respective Landlord Tenant Acts will follow this conclusion. Thank you. The website address for the Arizona Residential Landlord Tenant Act is www.sos.state.az.us.